Good morning, everyone, and welcome to today's HR and Employment Seminar. Thank you all for being with us this morning. My name is Marty Rabinovitch. I am one of the partners at Devry Smith Frank and am the head of the firm's employment law group. We have these seminars every few months. We had one on April 1st, so this is our second one of the year. We try and have these every few months, so the next seminar will likely be sometime in September or October. The program has been approved for CPD hours for both lawyers and human resources professionals. So we'll send you all that information. So be sure to claim your hours for all of the lawyers and human resources professionals in attendance. Here are the topics that we will be looking at today. We'll be looking at the reopening of the economy in the COVID-19 era, and we'll look at some tips and considerations for employers in this regard. We will then look at a new regulation that was enacted pursuant to the Employment Standards Act with respect to reduction or elimination of hours and deemed infectious disease emergency leave. And then we will end with a presentation on the enforceability of termination clauses, and we'll look at a case called Waksdale and Swegon North America, Inc. It's the latest in 2020 from the Court of Appeal. So here is today's agenda. So we will get through the three substantive topics back to back to back. There's about 20 minutes per topic there. I will just mention now that the first topic will likely be about a 25 to 30-minute presentation. The other two will clock in at about 15 minutes. So there will be about an hour of the substantive topics here. Then we will take a break, and then we will have a Q&A period. So at any time throughout the presentation or at any time during the break, which will happen at about 10:05, please feel free to submit your questions through GoToWebinar. I think you can just type in a question there. I will review all of the questions that are submitted, and I will answer as many of them as possible during the Q&A period. If I'm not able to get to your question, feel free to contact me, and I'd be happy to answer it. And I'm going to preempt here one of the most frequently asked questions that we had during our last seminar. Yes, the slides will be available to everyone. They will be posted on our firm's website shortly after the presentation, and they can also be emailed to you individually if you'd like. And as an added bonus, this seminar is being recorded. So if you feel like you would like to listen to either the entire thing again or at least part of it, you will be able to do that as well. All right, so let's get right into this. We'll look at reopening of the economy in the COVID area and what are some of the things that employers should be thinking about in this regard. Here is everything that we are going to look at in this presentation. I'm not going to read through all 14 bullet points here, but again, the slides will be available for everyone after, okay? So what is the coronavirus? I'm not going to go through this in detail. I'm sure you've all been paying attention to the news in the last several months, but it's basically a very, very contagious disease. It's a respiratory illness. Different people will show different symptoms, and unfortunately, it has resulted in many deaths around the world. The easiest way to stop the spread of the virus is basically to stay away from each other, at least 2 meters from each other. There is currently no vaccine or treatment yet. Clinical trials have been ongoing, and I just wanted to make a note here. There's one potential vaccine that's been developed by Oxford University, which recently got some news coverage. There were some strong early stage trial results. More full results are expected in the fall. And if those results are as successful as the earlier ones, there could be a vaccine approved for limited use by December of 2020. So we've heard a lot of bad news about COVID-19. I did want to highlight some good news, at least at the beginning of this presentation. There's all sorts of symptoms of COVID-19. Different people develop different symptoms. I just wanted to flag again here that those who are over 60 and those who have pre-existing medical conditions are considered to be at higher risk with respect to COVID-19, and that is going to be relevant when we get into some of the employer-specific recommendations later on. Physical distancing, staying home, washing your hands, these are all good ways to reduce your exposure to the disease. We'll talk more about this later. There is a reopening plan in effect now. In stage 3, the indoor gathering limits will be increasing, or have increased in most of Ontario from 10 to 50, and outdoor gathering limits will increase to a max of 100 for stage 3 of the reopening. Those are with physical distancing requirements, though. So reopening Ontario. So during the last seminar back on April 1st, the province was pretty much shut down, and the only businesses that were open were those that were deemed to be essential. So the good news now is the numbers are better, and Ontario has put together a multi-phase plan to reopen the economy. And it's basically a gradual approach which will permit public health officials to monitor and assess conditions before moving on into the next phase. It's going to be done, or is being done, on a regional basis. So, for example, Toronto is in stage 2, but just about the rest of Ontario is in stage 3. So not all businesses are permitted to reopen, and even those that are permitted to reopen are not permitted to reopen in their full pre-COVID-19 capacity. So in stage 1, here are some examples of businesses that were able to reopen: construction, retail, vehicle dealerships without appointments, golf courses, individual sports without spectators. So those are some of the examples of some of the restrictions that were lifted in stage 1. Here's some more examples as well. I won't go through all of these. Stage 2, it was the next level. So also a regional approach, same as stage 1. And as of June of this year, Ontario in its entirety, including Toronto, had entered stage 2. So in stage 2, sorry about that. So in stage 2, let's see here, where did we stop? Okay, so in stage 2, more businesses were permitted to reopen. So community, recreational, and outdoor spaces, restaurants for outdoor dining, and shopping malls with some restrictions. And physical distancing measures still had to be adhered to, and social gatherings were increased up to 10 people. Okay. So here's some other examples of businesses that were permitted to reopen in stage 2, and some more on some of the specific restrictions that were implemented. So a lot of this information can be found on the Ontario government's website. So if you need to determine, what your business can and can't do, and what some of the legislated restrictions would be, the government's websites would certainly be a good place to start. Okay. So this is all sorts of examples of stage 2 here and what can reopen. And now we get to stage 3. So most of the province currently is in stage 3. Again, Toronto is not. So stage 3 will consist of reopening most remaining workplaces, businesses, and community spaces while carefully and gradually lifting restrictions. So in stage 3, dine-in restaurants and bars are permitted, indoor recreational facilities, cinemas, gyms, amusement parks, water parks. Okay. We mentioned the increased limit on gatherings, 50 people inside, 100 outside. Big gatherings like concerts and sporting events with spectators are likely to be restricted for the foreseeable future, likely until the pandemic ends or until we get a vaccine or a good treatment. And, and this next point is going to be important for what all this means practically for employers. The government on its website has stated that working from home as much as possible is encouraged in all 3 stages of the reopening. Okay. All right. So tips and considerations. What does this all mean? What should employers do in response to all this? So the public health recommendations are really what will drive what employers should be doing. And as the public health advice changes, that should also change what employers should implement. So back in late March, early April, there wasn't too much conclusive research that had been done about the wearing of masks or face coverings. And the initial view was, well, don't bother wearing a mask. The mask should be saved for the health professionals. Okay. And now the research is showing that face coverings can stop the spread of the virus. And now we have bylaws in Toronto and many other jurisdictions, as we'll see, which require mandatory mask wearing in public spaces. So as the public health recommendations change, your business should also be changing what exactly it is implementing. And being proactive is also very important. So, for example, it's a good idea to have a plan about what your company is going to do if an employee calls you up and says, "Oh, you know, I just got my positive COVID test back over the weekend." So there should already be some sort of plan. Are you going to tell the employee, you know, that they can't come to work, and you know, figure out who they were in contact with at the office? Does your office have to close? Is there going to be some cleaning requirements there? So having that plan in advance can save a mad dash for the cash, you know, when something unfortunate like that happens. So in the Occupational Health and Safety Act, there is an obligation which is set out there for employers to maintain a safe working environment. Employers do have to take reasonable steps to protect the health and safety of employees, including exposure to COVID-19. Okay, and if the employers breach their obligations in that regard, they could be subjected to litigation. If there's WSIB coverage and an employee gets sick while they're at work, there likely would be some coverage there if the employee could actually prove that the contraction of the virus occurred at work. If there's no WSIB coverage, then it's going to be whether or not, you know, the employers took reasonable steps. So in other words, were they negligent in a certain way with respect to liability? So here are some tips and considerations. Please keep in mind that not every one of these suggestions will apply to all businesses. Some of them are geared more towards smaller businesses. Some of them, you know, may not be feasible in certain cases, but these are ideas to consider. Of course, if you're not sure, you know, what would be good in particular as it relates to how it may affect your legal risk, feel free to speak to a lawyer about that. So, as a very preliminary matter, a good first step is to simply determine whether or not it is necessary for the staff to be in the office in the first place. Okay, so I think many employers were pleasantly surprised that that their employees, you know, did their work and, you know, were generally productive from home. I'm sure there were some exceptions to that, but in particular, since the government is recommending that as much work be done as possible from home, as a starting point, employers should consider who actually has to be in the office, if anyone. Okay, and for those employees who are going to be working from home, now would be a good time to implement or to revise your company's work from home policy. and that policy should address issues like health and safety issues, productivity, hours of work, attendance at meetings, virtually, I guess, and that sort of thing. Okay. For those employees who do need to be in the office, it would also be a good idea to hold virtual meetings. So rather than packing, 20 people into a tiny boardroom, it may be better, to do the meeting by way of a phone conference or a Zoom video conference or something like that to avoid the physical proximity. Employees should monitor themselves for symptoms. So staff could be screened before they are permitted to enter the workplace. And one possibility, which has come up before with a few of my clients, is temperature checks. So in other words, you would have someone at the entrances to your business asking people, what symptoms they have, if any, and in some cases, subjecting them to a temperature check to see if they have a fever. Now, of course, that's not going to tell you on a determinative basis whether or not someone is infected with the virus if they have a high temperature, but it's one possible sign that the employee could have COVID-19 and perhaps should be at home. Having a plan if an employee contracts COVID-19, we talked a little bit about that before. Identifying any employees who may be at high risk. So are there any employees with pre-existing conditions? Are there any employees who are over 60? And come up with an individually tailored plan for those employees, which could mean allowing them to work from home. It could mean having them work staggered hours. It could mean having them work in a more isolated part of the office to make physical distancing a little bit easier. So there's all sorts of individually tailored accommodations that an employer could consider. Reviewing human rights policies to ensure compliance with accommodation of those with disabilities. Absolutely. Now is a good time to look at those policies and make sure that they respond to COVID-specific concerns. Employees should be aware of the plan, so communicate that to them clearly. And we talked a little bit about this, but staggered work schedules may be a good option. So instead of having everyone come in from 9 to 5, maybe you have a shift that's, something like, I don't know, 7 a.m. to 2 p.m. or 3 p.m. and then, 3 p.m. to 9 p.m. or 10 p.m. or something like that. Okay, so that's always a good option to try and have fewer people in the office. On the government's webpage, there are some guidelines for cleaning and disinfecting public areas. There is a link there. In some smaller offices, it may be helpful to have foot and distance markers on the floor to encourage physical distancing. It may be necessary to physically alter the layout of the office and to add some things. So maybe cubicle walls, should be increased of increased height. Maybe they should be spread farther apart. Some of the items that people would commonly touch in their waiting rooms, like magazines or pen trays or water jugs and whatnot, should be removed. And also in smaller offices, maybe policies to limit movement in the office. Okay, the expectation is that you're going to be at your desk or at your cubicle, and unless you have to use the restroom, unless you're coming, going, or eating, or something like that. Or even having directional arrows on the floor to make it clear that employees should only be walking in one direction. Okay. Air quality and air filtration is another interesting issue. This is a virus that can absolutely be airborne. Opening windows when it's warm outside is a good idea. Checking to make sure that you have a good air quality, good circulation and filtration system, very helpful. It may even be worthwhile to have an engineer or someone with expertise in the field come in and make sure that your company is doing well. We'll look at a study that was published in the New York Times a little bit later about an example of COVID-19 being airborne and being spread. We talked about temperature checks. There is now a bylaw in the city of Toronto which requires mandatory masks in public areas. So that would apply to your office. So you should be posting signs to remind everyone of that bylaw. What are you going to do about enforcing it? Well, I mean, you can ask people to put on a mask if they are not wearing one. I'm not sure that I would recommend, engaging in heated, debates about, why someone, does not think they should have to wear a mask or whatnot. But at the very least, you should ask them, to put it on, and you could consider, saying, well, if you don't put on the mask, I think you should leave. There's some human rights considerations about that, which we'll get to, but if you're polite and try and get people to wear masks, I mean that would certainly help. And even though the bylaw just says that masks are mandatory in the public areas of the office, some employers may wish to consider making masks mandatory throughout the entire workplace. Okay, so if your workplace is very small, if it's hard to physically distance, if you have employees, who tend not to stay at their desks or cubicles all the time and tend to like walking around and socializing, if some of those factors are present, you may choose to implement an office policy that requires masks throughout the workplace. Okay. Few other recommendations here. I mean, hand sanitizer, we've probably all done that. Plexiglass is a good one. So if you have a reception area that is very high traffic, it may be a good idea to put some plexiglass there, just to reduce the exposure there for your employees who are manning the reception. So I just want to look at the bylaw in a bit more detail here. So this is the City of Toronto bylaw, which came into force on July 6th of 2020. It's a municipal bylaw, so there's currently no province-wide mandate to wear masks in indoor public spaces, but many other municipalities have followed suit as well, such as Peel and York. Now, what's interesting about the bylaw, though, is that there are some mandated exceptions. So masks are not mandatory at places such as schools, post-secondary institutions, childcare facilities, so daycares basically, private and public transportation, hospitals, and basically the doctor's office, okay? Now, despite, for example, private and public transportation not being captured by the bylaw, the TTC has already made masks mandatory, and I believe Go Transit has done so as well. So just because you may be an institution that was not captured by the Toronto bylaw, you still could require individuals to wear masks, subject to human rights legislation. So that's going to have to do with if someone has a disability that would prevent them, from wearing a mask or putting it on or off safely. And there may also be some other legal or professional duties. So let's look at the example of a physician, right? So doctors' offices were not captured by the bylaw. Let's say there is a patient, that comes in and, wants treatment for something, but for whatever reason refuses to wear a mask, and they have no disability that would prevent them from wearing one. Well, if it's a non-urgent matter, the doctor probably could say, you know what, we have this mask policy at this office, please come back, when you're ready to wear a mask. But the situation may get more complicated if it is actually an urgent matter or potentially a life-threatening matter. And, then a doctor is going to have to weigh probably their ethical, thoughts on one hand, but also their professional duties. I mean, do doctors not have an obligation, to treat sick patients, right? So that can cause some difficulties, in particular in the medical world. Generally, I would say that health and safety is going to win out over the inconvenience of wearing a mask. Now, there are some individuals who will have some sort of respiratory disorder, reduced lung capacity, and whatnot that will prevent them from wearing a mask safely. I'm not a doctor, but from what I have read about what doctors have said, there are very, very few medical conditions that would render it unsafe for someone to wear a mask. I mean, there were stories in the news about people who had reduced lung capacity were nevertheless okay, wearing a mask, and their doctors were okay with it. Okay. So something just to keep in mind, that there is a duty to accommodate, and there are definitely going to be illnesses out there which may prevent someone from wearing a mask. But I just think that, at least, based on what we know now, there are just very few conditions which would make that applicable. Just an article here about working from home. I think generally employees have been pretty productive working from home. In fact, more so than most employers would have expected. So in an article in the Globe and Mail back in May, there was a comment that, if we assume that, as a rule of thumb, it costs about 20% of an employee's salary to have them come to work in the office. Let's say that, they're about 5% less effective when working from home. It's still, better for the employer to have that employee work from home in the view of this article. So something to consider for employers is, well, can we save money by reducing space? If we don't really need everyone to be in the office all the time, maybe some employees can permanently work from home, maybe some can work from home more often. This could be a potentially significant way for employers to save money on overhead. This is the study here in the New York Times that I wanted to mention about air quality. So this was a study. It was based on an incident which happened back in January. It was a restaurant in China. There were 3 tables in a restaurant that were more than 2 meters apart. And there was one person at the middle table who had COVID-19, I guess unknown to them, and through speaking or coughing, expelled droplets into the air. And despite the fact that 2 adjoining tables were more than 6 feet away, the study concluded that because this restaurant was poorly ventilated, there were no windows, that the restaurant's air conditioners apparently blew the virus particles around the dining room. And then there were patrons who were seated at the other 2 tables who were diagnosed with the virus. So all this to say is that ventilation systems are complicated. Airflow, I think, is pretty complicated. So professional assistance, is something to consider. But really just understand that, at a restaurant, for example, placing tables 6 feet apart, may not be enough to safeguard your patrons, in particular if they're going to be there for an hour, 2 hours, or whatnot. Okay, so that's an interesting study to keep in mind. We're going to get in now to refusing to work. This is another common issue that has come up. Okay, we have seen that employers have a duty to provide a safe workplace. Okay, however, an employee cannot refuse to work simply because of a general fear of contracting the virus. They have to point to something more specific. Okay, to be clear, there is some uncertainty. This hasn't been tested fully in court. Okay, but this is likely where things will land. Okay, so if an employee comes back to work and says, well, I came back to work, but you have no social distancing policy, or I came back to work and you have the policy, and everyone keeps coming too close to me, I tell them to go away, I made a complaint, but you're just not enforcing the policy, then probably that employee would be able to refuse to work. Okay, if a receptionist with a high traffic reception area says, well, can you please just put some plexiglass in, I'm coming into contact with hundreds of members of the public every day, and the employer says, well, no, then that receptionist may be entitled to refuse to work. Okay, so for employees who are refusing to work, employers should consider whether it's possible to accommodate them. So can we install the plexiglass? Can we have them work different hours? Can they be permitted to work from home for at least part of the time? Okay, And keep in mind that if an employee refuses to work without a valid legal reason, they may be found to have abandoned their job. So, I mean, you can explain that to employees. If you're feeling a bit nicer as an employer and you want to keep the employee on, you could say, okay, well, why don't we work out an unpaid leave of absence for, I don't know, say 3 months. And then when you feel safe again, you can come back to work and you're still going to be employed. So employees can't decline work or unilaterally decide where or when they feel like working. Okay. They can't just decide that, ooh, I would rather stay home and sit on my couch and collect my SIR benefit if they are offered work. It doesn't quite work that way, even though it seems like that is happening in many cases right now. There has been some talk about the government introducing legislation to disentitle people from the SIR if they were offered to return to work, and it would be reasonable in the circumstances for the employee to do so. That's not law yet, but there's been talk of it. So employers have to consider the following. If you have an employee who says they don't want to work, is the employee entitled to some sort of unpaid leave of absence related to COVID-19 or some other unpaid leave under the ESA? Are they entitled to an accommodation under human rights legislation? And, are they permitted not to come to work because there actually is something that's unsafe that needs to be addressed? Okay, so if an employee says, I don't want to come back to work, you should have a conversation with the employee about everything, and see if you can come up with an accommodation. And I think that employers may be pleasantly surprised in that regard. Okay, so that is the end of the COVID-19 topic. We are going to move right into the next topic, which is about reduction or elimination of hours and deemed infectious disease emergency leave. So this is a new regulation that was enacted under the Employment Standards Act. Okay, so here is a quick overview of everything that will be included in this presentation. I'm not going to go through it, it's on the slide. Okay, so a little bit of background on temporary layoffs. All right, so at common law, employers don't have the right to temporarily lay off employees. The right to lay off an employee comes from a contractual term. So the term can be simple. The employer may temporarily lay you off in accordance with the provisions of the Employment Standards Act. That's all it needs to say. Okay, but if there's no such term, at common law, the employee would have the right to claim for constructive dismissal. Okay. If we're looking at this in the Employment Standards Act, employers can temporarily lay off employees, and there are specific rules about that. And the length of the layoff period changes based on certain factors. Okay. So here is the section in the ESA that is relevant for layoffs. So the base layoff period is 13 weeks in a period of 20 consecutive weeks. And then that period increases to 35 weeks in a period of 52 consecutive weeks. If one of the following conditions here is met. The most common one is that the employer simply continues the employee's benefit plan contributions throughout the layoff period. Okay, so here's a summary of what you're looking at here. Now, the coronavirus caused some difficulties for many businesses, lots of terminations, lots of employees who were placed on temporary layoffs. In May, there was this new regulation that was passed that we'll be talking about. But just for some context here, by June, approximately 2.2 million Ontario employees had either lost their jobs, so they were fired, or they had their hours significantly reduced. So the government introduced a regulation to try and help employers with this, okay? So what the regulation says at a very high level is that For non-unionized employees whose employer has temporarily reduced or eliminated their hours of work because of COVID-19 is deemed to be on infectious disease emergency leave. Okay, infectious disease emergency leave is a job protected unpaid leave of absence. Okay, and when the leave was introduced, it was basically meant to say, okay, if you're sick with COVID, if you have to take care of your kids, or you can't work because of COVID, you're on this leave. So now, if an employer reduces or eliminates hours because of COVID-19, now employees are deemed to be on this job protected unpaid leave. The employees are still eligible for a federal emergency income support program, so they would still be entitled to receive CERB and probably EI as well. Okay, and then there is a limited timeline of applicability. So it does go retroactive to March 1st of 2020, okay? And then it ends 6 weeks following the declaration of emergency. The latest news is that the declaration of emergency, I believe it is supposed to end sometime this month, perhaps by the end of the week. So 6 weeks following puts us in early September. So what the regulation says is that the temporary reduction or elimination of an employee's hours or wages by the employer for reasons related to COVID-19 shall not constitute a constructive dismissal. Okay, so no constructive dismissal with respect to the Employment Standards Act. Okay, and if an employee files a complaint to the Ministry of Labor with respect to constructive dismissal, then it's basically deemed not to have been filed. So no statutory constructive dismissal anymore, okay? The regulation also specifies when hours are considered to be reduced. So if the regular work week hours are fewer than the last regular work week prior to March 1st of 2020, there's a reduction. If there's no regular work week, you're comparing it to the average hours worked over 12 weeks prior to March 1st. And if the employee was not working at all during the last week, then you're comparing it to the week in which they worked the greatest number of hours. Okay, and the rules are similar, as we'll see here, for when wages are considered to be reduced. Okay. Now, the question is whether this regulation is going to affect the common law of constructive dismissal. Okay, and for the reasons which follow, I'm going to suggest to you that probably the common law is not altered and that employees are still able to pursue constructive dismissal claims related to reduced hours or reduced wages at common law. Okay, and the reasons why I say that are, first of all, there is no language in the regulation which expressly says that this is meant to override the common law. It is absolutely possible for the government to introduce legislation to essentially override a common law principle that it does not like. Okay, but it's also been well-established law that if that's what the government is intending to do, there has to be very clear language to show that intention, and there is no such language in the regulation. Okay, and the other reason why I say that probably the common law has not been altered is because of Section 8 of the Employment Standards Act, which says, subject to Section 97, which is about something unrelated to today's subject matter, no civil remedy of an employee against his or her employer is affected by this act. Okay, so the next question is going to be, well, how do we get around that? Okay, if there's a section of the ESA saying that it's very, very clear that nothing in the ESA affects what an employee can do civilly, we're going to have to get around that in some way, shape, or form, and I'm not sure that we can. Of course, there's still uncertainty because the courts haven't weighed in on this. One possible outcome is that the courts will still find that there was a constructive dismissal at common law, but simply award less generous severance packages. It's also possible that the courts may say, look, the government was very clear, based on this regulation that, it didn't want there to be constructive dismissal claims related to COVID. So, we're not going to award, damages for constructive dismissal in that context. All of these are possible outcomes, but I still say that, based on the information here on this slide, that the common law will likely be found not to have been altered by the regulation. Now, it may be difficult to reconcile, how an employee could possibly be on a deemed unpaid leave of absence for the purposes of the Employment Standards Act, but yet constructively dismissed and not employed at all under the common law. But what I would say to that is this is exactly what the courts have already accepted with respect to temporary layoffs. The courts have accepted that you can be properly temporarily laid off under the Employment Standards Act, but constructively dismissed and not an employee anymore at common law. So I think that the courts have accepted this sort of reasoning before, and I think that most likely they will accept it again. Okay, so the key employer takeaways from this new regulation. So employers may reduce or eliminate an employee's hours or wages for reasons related to COVID-19 without being obligated to pay out severance and termination pay under the ESA. Okay, but note that if the employee was already terminated at some point between March 1st and May 29th, the termination stands. They don't all of a sudden become re-employed again and they go back on the deemed leave. No, if they were terminated already, they are still terminated. Employees will likely not be barred from pursuing civil constructive dismissal claims as a result of the regulation, and the applicability of all of this expires 6 weeks after the state of emergency ends, which appears that it will be sometime in September unless the state of emergency is renewed once again. Okay. So that concludes the presentation on the regulation, and we will now move right into the last topic before the break, which is Waksdale and Swegon North America, Inc., and the enforceability of termination clauses and the latest blow to employers. So you can probably all see where this one is going. Here's a quick overview of everything that will be covered in this presentation. We'll look at a couple of cases, overview of termination clauses, the difference between the common law standard and ESA standard with respect to terminations and so on. Okay, so by way of quick background, when we're talking about termination clauses, we're talking about language that sets out an employee's entitlement upon termination. So it will include things like pay in lieu of notice, severance pay, and benefit continuation. Okay. Most termination clauses are drafted in favor of the employer to limit the employee's entitlement upon termination without cause. And courts will not, they've been very clear about this, they will not enforce termination clauses which breach the ESA by providing a lesser right or benefit to the employee, or that could breach the ESA in the future. And common law reasonable notice is usually significantly greater than the employee's termination entitlements under the ESA. Okay. Okay, so why are termination clauses often struck down by the courts? For a number of reasons. Basically, if the employer is seeking to provide the employee with less than their minimum entitlements under the ESA, the clause will not be enforceable. So if there's a termination clause which would provide a lesser entitlement with respect to termination pay, severance pay, benefit continuation, commissions, something like that, then it's not going to be enforceable. A termination clause can also be unenforceable if it could provide less notice than what the ESA would provide for. So, for example, the ESA requires employers to give 1 week of notice per completed year of service, up to 8 weeks. But if you had a termination clause which said, well, you get 1 week per year of service, but the cap is 4 weeks, well, now it's unenforceable because it could be it could be not compliant with the ESA once the employee starts working for 5 years or 6 years, and so on. Okay. Another common problem is that the termination clauses don't provide for employer benefit plan contributions throughout the statutory notice period. Here are some of the cases in which that principle is set out. Termination clauses can be unenforceable if they're unclear, confusing, vague, or ambiguous. So the language here would probably not be upheld. And to be clear, if there is no termination clause, or if there is an unenforceable termination clause, the employee gets their significant reasonable notice entitlement at common law. Okay. The Supreme Court has also weighed in on this issue as well. The Supreme Court has made statements about how employment is very important to our society and to employees' life, and it's an essential component of their sense of identity, self-worth, and emotional well-being. So it's very, very important for employers to treat employees well and fairly, in particular throughout the termination process, and things that relate to the termination of employees generally. So if an employee is terminated without cause, and they are entitled to termination pay and severance pay under the Employment Standards Act, okay? But to deprive an employee of their entitlements under the Employment Standards Act, the employer must show that they have engaged in willful misconduct, or as set out in the regulation, willful misconduct, disobedience, or willful neglect of duty. Okay, and this is set out here in one of the regulations to the Employment Standards Act. Okay, that's a very high standard. Okay, and there are lots of cases here that that set out what that standard is. I'm just waiting for my slide to change over here. Okay, there's a bit of a delay or something going on. So here's the slide from the regulation. Okay, so there's all sorts of cases here about defining the standard of willful misconduct. They're on the slides. I'm not going to go through all of them in detail, but basically it's a very high standard for an employer to prove. The employee must have consciously and deliberately engaged in some sort of positive act of misconduct. Okay, being bad at your job is not willful misconduct. Forgetting to do something is probably not willful misconduct either. Okay, so really you have to show that that there has been a deliberate act of misconduct on the part of the employee. Okay. So where am I here? Okay. So there's more on willful misconduct here. Okay, I'm not going to go into all of the cases here, but just remember that it's a very, very high standard. Okay. In order to deprive an employee from their entitlements at common law, okay, the test is just cause, and it is a lower threshold to meet than willful misconduct. So to be clear, there are scenarios in which an employee could be found to have been terminated for just cause at common law and would be entitled to 0 at common law, but yet was not terminated due to willful misconduct and would be entitled to termination and severance pay because the standard is higher. Okay, so for just cause, we're basically looking at, I mean, we're still looking at, whether the employee has engaged in misconduct. that would essentially permit the employer to say, look, the employee just no longer intends to be bound by the employment contract because they've engaged in behavior that is just so bad. Okay. But just remember that it's a lower threshold. Okay. I'm going to just go through some of the slides here, I think, for now. Okay, so here are some examples of what could result in just cause. Okay, there's a whole lot of them. You can look at those later. Okay, so let's look at a case now called Kashaba and Procom Consultants Group, Inc. Okay, so what happened here was there was a termination clause which basically contained a for cause and without cause provision. Okay, and this was the for cause provision. Okay, the problem with the for cause language here, though, was that it's basically said that if the employer terminated the employee for cause, the employee would not be entitled to anything. Okay, and the problem with that, as we saw, because there's now two standards, is this clause does not recognize the fact that there could be circumstances where the employee was terminated for cause, but yet would have been entitled to their ESA termination pay and severance pay. Okay, and then there was a termination without cause provision. It's long, you don't really have to read it. For the lawyers who are attending, you can read it later, but basically it's limiting the employee's entitlement to the ESA minimums in the event of termination without cause. Okay, so in Kashaba, the employee gets terminated without cause. Okay, and the employee says, well, we don't think that the termination without cause language should be enforceable because the for cause provision is enforceable, and we think that should take down and invalidate the entire termination scheme. Okay, and the court looks at it and says, well, yes, I agree that the provision about cause is unenforceable because it does not incorporate the willful misconduct standard, but the termination that's relevant here is termination without cause. There's a separate term, it's enforceable. So no, the termination without cause provision stands, and the employee is entitled only to their minimum entitlements. Okay, so in Kashaba, the court was prepared to uphold termination without cause language because it was separate, and that clause was unenforceable. That clause was enforceable, sorry, on its own. Now in Groves, this was another case where the issue was raised, and I really just bring up Groves here to say that the court did raise the issue here. The court acknowledged, that there are two standards, but because the termination clause had already been found to be unenforceable, for other reasons in Groves, they didn't actually have to make a determination on that. But the issue about the two standards was noted. Okay. The court in Groves as well said, there was a savings clause here which said, well, if there's a problem, then don't worry, the employee's not going to, get less than their ESA. And the court said, well, no, just because you have some generic saving provision, doesn't mean that we're going to allow you to draft, clauses that aren't enforceable. Okay. And then we get to Waksdale. Okay, so here is a summary of what the court found in Waksdale. So first of all, the Court of Appeal held that in order for a termination scheme in a contract to be enforceable, including both the termination with cause and without cause part of the scheme, all termination provisions must comply. If part of the termination scheme is unenforceable, it is irrelevant whether there are separate and distinct termination provisions that would otherwise be enforceable on their own. Unenforceable termination for just cause language renders termination without cause language unenforceable, even if it otherwise would have been enforceable. And this applies even if the employee was terminated without cause. So in Waksdale, I mean, it was a similar situation to Kashaba, where there was a termination without cause. There were separate termination for cause provisions and termination without cause provisions, except what happens is at the trial level in Waksdale, the court follows Kashaba, but then everything gets changed at the Court of Appeal. The Court of Appeal says, well, we don't care if there's separate and distinct clauses about termination for cause and termination without cause. We don't care. If you're going to rely as an employer on a termination scheme, if there is any problem with the termination scheme, that whole termination scheme fails. And we don't even care if it's a clause that's not even, being relied on in the circumstances of the termination. Okay, so there we go. Here, so when part of a termination scheme is deemed unenforceable, severability clause is not going to help, but the whole termination scheme falls as well. Okay, here are some more details about the facts of Waksdale, which you can have a look at on your own. The parties did agree in this case that the termination for just cause language was unenforceable. So that was not an issue that the court actually had to decide. And the with notice provision stated that Waksdale would receive the minimum amount of notice and statutory pay under the ESA plus an additional 1 week of notice. Okay, so this was an example of the termination of employment with notice clause that was contained in the contract. Okay, so the parties did agree, or the employer conceded, that the clause violated the ESA and was unenforceable. So we don't actually see the language of the cause provision quoted in either the trial or Court of Appeal decision. It would have been nice, just for confirmation to see that. And one argument that I have heard and I have made before is, well, we don't even know, what this unenforceable termination for cause clause is. So, why is this case, necessarily changing everything? But I don't really think that actually matters, because the overriding principle is that if part of the termination scheme is unenforceable, the whole termination scheme fails. So I don't really think it matters actually what the language is. Okay. So the lower court decision, as we talked about, basically followed the reasoning in Kashaba, but then this gets overturned by the Court of Appeal. And one of the reasons that the Court of Appeal relied on policy-wise in its decision was that if an employer implements a contract which is actually not compliant with the ESA, the employee may not know that and may take steps to comply with those provisions even if they never really had to. So in other words, the employers can gain a benefit over their employees by drafting unenforceable language, which is not fair, and the courts wanted to make a statement about that. Okay, so it's an employee-friendly interpretation of everything here. Okay. So here are some of the overriding principles here. It doesn't matter whether or not the termination provisions are contained in one paragraph or whether they're separate and distinct. If part of the termination scheme is unenforceable, the whole termination scheme is unenforceable. Okay. Severability clauses are also not going to help you here. And every termination clause must be evaluated by its wording at the outset of the employment relationship. So it doesn't matter the manner in which the employee is terminated. So whether it's cause or without cause does not matter. Okay. And then here, The court also reminded us about the decision in Wood and Fred Dealey, which basically says, look, the ESA is there to protect employees. There's an imbalance of power. Employers should be encouraged to draft, termination clauses that comply. Okay. So overall, this is another case that I wanted to mention before we conclude here, called Rutledge and Canaan Construction. So the takeaway here is that even a remote possibility that a contract might become illegal in the future can void the entire ESA termination clause. Okay, so in this case, a construction employee's contract stated that he was not entitled to ESA termination pay. And the background here is that if employees meet the definition of construction employee under the Employment Standards Act, then they're not entitled to termination pay or severance pay. But the court says, well, no, there actually is a possibility that one day the employee may not be a construction employee. So in that case, they would, or at least could be entitled to termination pay and severance pay. So we're not enforcing this termination clause. Okay, so a particular note there for anyone here who works at a construction company, if you have any language like this, probably we should have a look at it. Okay, so what is the significance of everything here? So Waksdale likely has rendered many termination schemes unenforceable because many employment contracts do have a clause in there that says if we terminate you for just cause, then you're entitled to nothing. But now that's going to need to be revisited. Okay, so now is definitely a good time to seek legal advice about your employment contracts, and in particular, the termination language. I would suggest that as an employer, your contracts probably should be reviewed annually by a lawyer, just to make sure that they're still compliant with the laws. And as the title of the presentation suggests, what is the latest blow to employers going to be? So just to make sure that at very least you're reacting to the latest blow, whatever the next one might be. Another possibility is to simply offer employees an amount greater than what is in the ESA, but less than what their common law entitlement is likely to be, to avoid arguments that you are contracting out of the ESA and you are offering your employees a lesser entitlement. Okay? So this is exactly it. What will be the next problem? Right? So I don't know what the next problem is going to be. Sometimes it's hard to say. Courts clearly do not like these termination clauses, which are seeking to limit the employee's entitlement. So maybe just offer more than the ESA and reduce exposure that way. Okay? So for many of you who have a just cause or termination for just cause provision, the way to fix it in response to Waksdale is to recognize that there may also be some entitlement under the Employment Standards Act. So here is, an example of language which could be used. Again, don't worry, the slides will be available, okay? And then if you want to change the approach a little bit and say, well, we're just going to offer ESA plus 1 week per year of service, for example, there's also another example here of how you could do that. Okay, that concludes the presentation for today. Thank you for your attention for the last hour. We are now going to take our 10-minute break. I am going to take a look at some of the questions that were submitted. It's about 10:04, so we'll come back at about at 10:15. I will answer as many questions as I can, and then we will wrap up today. So enjoy the break. Thanks very much, and we will be back shortly.